Very good morning, students of class 8. Today we will continue our discussion, Civics chapter 18, the Judiciary. In that, we have to discuss today the High Court, composition and powers and functions of the High Court. Last class, we had discussed and studied and try to understand about the Supreme Court and then functions and powers and composition, etc. So let's go through the lesson to understand properly this topic. High Court. According to the Constitution, each state in the country can have a High Court which is the highest judicial authority in that state. Some high courts have 2 or more states and union territories under their jurisdiction. For knowing sake, I would like to tell you, in India there are 28 states at present, 28 states and 8 union territories. In that, these all including, there are 24 high courts. High courts at present, 24 high courts, and there are 28 states and 8 union territories at present. So some of the states and union territories, they share their high courts. In the last class I had told about that. The Guwahati High Court shares all the 7 sisters. 7 sisters means 7 northeast states. Thus, similarly, I will explain about that. There is a Chandigarh High Court, 2 states and Chandigarh Union Territory, they shares, the Punjab state and Haryana and that Chandigarh Union Territory. The similar way, in the Kolkata High Court shares by West Bengal state and Andaman Nicobar Island. Likewise, some of the High Court share 1 or more than 1 state or some of the union territories. So compositions of the High Court, it is not fixed like Supreme Court. In Supreme Court we had studied the composition of Supreme Court, 1 Chief Justice of Supreme Court and not more than 30 other judges, means there is a fix, but if required they can increase the judges number in that Supreme Court. But in a High Court there is no fix, it is depend upon the size of the states, the problems of the disputes of the particular states. So there is not fixed in every state, but there is a differences. At the High Court's level is the Chief Justice. There are a number of other judges. His number is, or this number is decided by the President according to the size of that state, which one I had told. But every High Court there is a 1 Chief Justice of High Court and judges appointed by the President of India according to the size and according to their disputes and the work level. Third, the President appoints the Chief Justice of the High Court and the other judges in consultation with the Governor of the state and the Chief Justice of India. Means that whatever the Chief Justice of High Court appointed, whoever, means with the consultations with the particular governor, particular state's governor and the Chief Justice of India, means Chief Justice of Supreme Court, they give a advice to the President of India, then the President of India appoints as a judge of that particular state. The qualifications of the judges of a high court: first, they must be citizen of India. It is in all the factor, either you are that being a employee of the any government, or you contest the elections of the Lok Sabha, Raj Sabha, or state legislative assembly, municipalities or municipal corporation, or the village level, the sarpanch or mukhiya or pradhan election also require that a person should be a citizen of India. Second, they must have held a judicial office in India for at least 10 years, means judicial office in India means he must work in the subordinate court or in the high court around 10 years. Next, they must have been for at least 10 years advocates of a high court or of 2 or more such courts in succession, means a appointment of the Chief Justice of the High Court require at least a person should work as an advocate 10 years, maybe from one high court or the another, or 2 or 3 that high courts within 10 years, but he should work as a advocate, then only the person can be eligible for the judges of High Court. Judges of the High Court serve until they are 62 years old. They can resign earlier or can be removed from office by the President if they are impeached by the same process that applies to the judges of the Supreme Court. Here we will get some differs in the Supreme Court. Supreme Court age factors that judges of the Supreme Court retired when they attain 65 years, and that High Court when the judges and the Chief Justice of High Court attain 62 years, then they retired, and they can vacant if they resign from the post, maybe for various reason, maybe health reason, family reason, or any other reason can resign, then the post of judges of the High Court can vacant. Or one another thing is that impeachment process. Impeachment, earlier we have seen impeachment means if a judge or Chief Justice of High Court use his post and gives anyone the benefit, or the violate the rules of the Constitution, then the person can be that impeached, and then that his or her post vacates. Now we will talk about the powers of the High Court. What are the powers are there? First, a High Court has original jurisdiction. As there is a original jurisdiction in Supreme Court, the similar way High Court has also original jurisdiction. That is, it can hear original cases brought to it for the first time. These cases can involve disputes concerning fundamental rights, election petitions, and the related disputes. As it was in the Supreme Court, we had studied the union government problem and the 1 or 2 or more states problem, disputes directly goes to the Supreme Court, then that is known as a original jurisdiction. And here that The original jurisdiction means maybe that civil criminal or maybe revenue that cases may be known as that directly come to the high court, that is known as the original jurisdiction. And the fundamental rights, violations of the fundamental rights, election petitions or related disputes. Second, a high court has appellate jurisdictions also, where it can hear appeals against judgment passed in subordinate courts such as the district court. Means here we can see that high court also have a appellate jurisdiction, means any case, कोई केस डिस्ट्रिक्ट कोर्ट में या सबऑर्डिनेट कोर्ट में ऑलरेडी प्रोसीडिंग्स हुआ और फाइनल जजमेंट वहाँ से दिया गया. ए क्लाइंट, ए विक्टिम पर्सन, if not satisfied with the judgment of the district court or subordinate court, a person can appeal in high court. That is only known as a appellate jurisdiction. Next we have to see the high court can review and change decisions taken in the subordinate courts. It can also transfer a case from one court to another. Means any kind of the decision given by the district court or subordinate court, डिसीजन दे दिया गया है और एक व्यक्ति जो क्लाइंट है वो सेटिस्फाई नहीं है उस डिसीजन से, तो वो अपील कर सकता है हाई कोर्ट में. तो हाई कोर्ट का कर्तव्य होता है अपने से नीचे कोर्ट जो सबऑर्डिनेट कोर्ट है या डिस्ट्रिक्ट कोर्ट है उनको ऑर्डर देता है और उससे रिव्यू कराता है. हो सकता है कोई एरर से कोई गलत डिसीजन उनको दिया गया हो, तो ऐसे में हाई कोर्ट जो डिसीजन लिया गया है, जितना भी केसेस हैंडल हुआ, जब भी हुआ, डेट्स कब हुआ, क्या क्या प्रोसीडिंग्स हुआ, सारे का सारे केसेस को रिव्यू करता है. सो दैट इज नोन एज ए हाई कोर्ट रिव्यू. Next, a high court also controls and supervise the functioning of subordinate courts. Means high courts work also that give a advice, suggestions and controls and supervise to the district court or subordinate courts. Next, it has revisory jurisdiction in case where it feels that the lower court have done beyond their jurisdiction. Means revisory, they revise that punishment given by the subordinate court or the district court. Next, it maintains records of the proceedings and decisions. These records serve as references for lower courts in future cases. Means as we have talked about court of record, so that one also the high court also have, and they keep a record. Next point we have to see about the writs. Writs, a official order or directions, about that we have to study. Both the Supreme Court and the High Court are empowered by the Constitution of India to issue writs for the enforcement of fundamental rights. A writ is a form of written command or legal document giving order or directions to a person to act or not to act in a particular way. Some of the writs are the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto, etc. There are 5 writs, important writs to give a command, order or the direction to the lower courts. So the writ is in both High Court and Supreme Court have a writ. They can use of that empower by the Constitution of India. and they can enforce of the fundamental rights. First, habeas corpus. The Supreme Court or High Courts can issue these writs to somebody who has detained another person illegally, commanding him or her to bring the person into the court and to state the cause of arresting him or her. Second, mandamus. This writ is issued to compel a lower court or an official or individual to perform their duties and certain acts. Prohibitions. This writ can prevent a lower court from exceeding its jurisdiction and keeping it within the limits of its own jurisdiction. It can be used to check misuse of power. Fourth, writ of certiorari. This writ can be issued to compel lower courts to hand over the record of a particular case to a higher court. And the fifth, quo warranto. This writ can be issued against a person who had wrongfully occupied an office. So, students, kindly go through your lesson for your better understanding. Next class we will see subordinate courts, panchayat courts, lok adalat and legal aid. Thank you so much.